just hit 10 a.m. So let's go ahead and get started. I think you guys all know me. We invited our clients to this special episode and screening of what you need to know as you start to reopen your business. Um, as we hopefully are in the end of the pandemic, and I have Angela Serranzana here with me as well. Angela's been with our firm for a number of years and probably is the attorney working on a lot of your cases if you have open matters with us. So, um, so I think you guys all know my story or a little bit of background. I always knew I was going to be a lawyer. I started working at an employment law firm when I was in high school. And when I started working there, I went to my dad who was running a business and I'm like, Dad, you really need to be keeping track of breaks and lunches for your employees. And he didn't want to hear it, right? He was like, no, what do you know? You're in high school. I think I'm good. My employees are my friends. And that's what I hear from a lot of business owners today. And so after some time of me like really, really pressing, he wasn't interested in what I had to say. And he then had an employee threaten him and say, I've never taken a break. I've never taken a lunch. I think I have a claim against you. And that's when he came back to me and he's like, Cindy, what were you saying about logging breaks and lunches and things like that? And I'm like, oh, here's what you need to do, Dad, right? Now, Angela's parents, Mr. and Mrs. Serranzana, seem to be the opposite, right? They actually have a Google alert on her and get updates on every time we post a webinar, which is one of the reasons why I wanted to do with Angela today. I want our 2 YouTube viewers to view us. So a special hello to Mr. and Mrs. Serranzana. One is a doctor and one is a nurse, and they listen to our webinars, and they aren't even in California. They're in Oregon.
Hi, Mom and Dad.
Proud parents, right? So that's kind of fun. All right, so let's get started with why you all came here today. I know you didn't want to hear about our family dynamics, but I am gonna share my screen. And I'm gonna hopefully get a thumbs up from Angela in just a minute that I am sharing my screen, because I've done I've done a lot of webinars in the last year, and I've forgotten to share my screen before. So, all right, thumbs up that everyone can see it. Okay, wonderful. So we're going over the most important California law updates as of right now, and it's April 2nd. A lot came down in just the last 10 days with what Governor Gavin Newsom has signed for us California business owners. And so we wanted to give everyone an opportunity to ask any questions along the way. You can put it in the Q&A. You can also chat us or email us, afterwards as well. But I will say this is our disclaimer, because Angela and I are both attorneys. That content on this webinar is not considered legal advice, and it's for informational purposes only. We understand that so many of you are our clients, and we definitely have a attorney-client relationship. But if you're just participating in this webinar and you're not one of our clients, this does not create an attorney-client relationship. Additionally, we're not responsible for any content that you can access from third-party resources that may be linked or accessed through this webinar. So that being said, Angela?
Oh, just a reminder to everybody, if something on the webinar twigs something in your brain, just shoot us an email and we can talk it through.
Absolutely. We're always happy to do that. So for today's topic, we're going to be talking about COVID paid leave laws, the American Rescue Plan, best practices for returning to work, and new wage and hour law, case law that's come down in the last few months. So quick overview. Okay, on March 19th of this year, our governor signed Senate Bill 95, which creates a new labor code section and mandates that employers provide employees with supplemental paid sick leave for various COVID-related absences, in addition to paid time off benefits employees receive by law or by policy. So this is non-COVID statutory paid sick leave or vacation. Additionally, SB 95 creates a new labor code section which mandates that providers of in-home supportive and or waiver personal care services receive this supplemental paid sick leave. These new statutes will apply retroactively to January 1st of 2021 and are effective through September 30th as of right now. Which can get a little tricky because technically they don't begin until March 29th, 10 days after the governor signs the law, but it's retroactive to January 1st.
And just to sort of explain that a little bit more, I can't remember, Cindy, if there is a slide on this later. But what that means is if you have any employees who took leave for a covered reason from January 1st to March 29th, that would encompass that. Upon a request by the employee to have that leave retroactively covered, you are required to include the pay for that leave in their next paycheck. So the next pay period after their request should include the payment for that leave that they took from January 1st to March 29th.
Right. And this is for employers with 26 or more employees, and the covered employees and family members. So the result is that far more employers are covered than those covered by the 2020 COVID-19 supplemental paid leave law, which was limited to employers and hiring entities with 500 or more. The 2021 law does not apply to employers with 25 or fewer employees. So if you are a smaller company, you don't have to go through the rigmarole of keeping track of this, but this new section 248.2, covers all employees of the covered employer. Additionally, it allows employees to use leave to care for family members, something that the 2020 law did not. And a family member is defined to include a child, grandchild, grandparent, parent, sibling, or spouse. So that was drastically expanded, which if you've seen any of our webinars thus far this year, you would know that. So qualifying reasons for the use of this emergency supplemental paid sick leave there are quite a few actually. So one of them is that the covered employee is subject to a quarantine or isolation period related to COVID, as defined by an order or guidelines of the State Department of Public Health, the federal CDC, or a local health officer who has jurisdiction over the workplace. If the covered employee is subject to more than one of the foregoing, the covered employee shall be permitted to use COVID-19 supplemental paid sick leave for the minimum quarantine or isolation period. Another qualifying reason is that the covered employee has been advised by a healthcare provider to self-quarantine due to the concerns related to COVID. The covered employee is attending an appointment to receive a vaccine for protection against, the virus. Another reason is that the covered employee is experiencing symptoms related to the vaccine, a COVID-19 vaccine, that prevents the employee from being able to work or telework. And so a lot of people who have gotten the vaccine in the last 3 months, they would get that, this paid sick leave. A couple other qualifying reasons for the sick leave is that the employee is experiencing symptoms of COVID and seeking a medical diagnosis. So in that time frame, the covered employee is caring for a family member who's subject to or advised to self-quarantine. And then lastly, the covered employee is caring for a child whose school or place of care is closed or otherwise unavailable for reasons related to COVID-19 on the premises.
So just that was a lot of reasons. I will just say that this leave is it's very much the same as the reasons under FFCRA, the federal law that was signed into went into effect back in March of last year. the only things that are different are they've added 2 additional qualifying um, reasons, and we'll see this in the federal law that was just passed, but to include vaccine appointments and symptoms related to getting the vaccine.
That comes to the next question: how much sick leave does an employee get? The process for determining the amount of leave is the same that was in effect last year. The leave amount also represents how much leave employees can use through September 30th of 2021. So for full-time employees receive 80 hours if either their employer considers them to work full-time, or on average, they worked or were scheduled to work at least 40 hours a week in the prior 2 weeks that they took the leave. For non-full-time employees with a normal weekly schedule receive the total number of hours that they are normally scheduled to work over a 2-week period. So whatever that comes out to. And then there's also this variable schedule. So employees who work a variable number of hours, whose tenure is 6 months or more, receive 14 times the average number of hours they worked each day in the 6 months preceding their leave. If they worked only between 15 days and 6 months, use the same calculation, but over the entire period of employment. Employees who worked 14 days, or fewer, receive leave hours equal to or total to their total number of hours worked. So that's a little bit of a complicated thing that you need to work out if you need help with calculations. And Angela and I do not know math, or I'll speak for myself. I'm not a mathematician, but I'm sure we can help walk you through that.
Yeah, just basically, you pull up their work log for the last, month, and you take the average of all of the days that they work. You look at the number of hours. Say they worked 4 hours on, one day, and 10 hours on the next, and 12. Add it up, take the average, multiply it by 14.
That's right. And we actually got a good question in the chat. I know Angela already answered it, but just to read it out loud to everyone. The question was, can someone use supplemental paid sick leave to take a family member to receive the COVID-19 vaccine?
As the language of SB 95 does not include taking a family member to a vaccine appointment. It covers your own personal vaccination appointment, but it does not technically cover taking a family member. That being said, you could probably finagle it and argue if you wanted to provide that leave for an employee, you absolutely can. It's just not technically covered, so you're not obligated to provide paid supplemental leave for that reason.
Okay, so the amount of paid sick leave already received in 2021 before the law takes effect might qualify as an offset that wholly or partially satisfies an employer's obligations under this supplemental paid sick leave. So under the law, if an employer pays an employee another benefit for leave taken on or after January 1st of this year, that is payable for the law's covered reasons and compensates employees in an amount equal to or greater than the amount of pay the law requires. We discuss pay further in another slide because I already see a question in the Q&A. But an employer may count those hours towards the number of hours of this supplemental paid sick leave, and it must provide an employee under the new law. So this must be a supplemental benefit. So employers cannot count paid sick leave employees used under California's Healthy Workplaces, Healthy Families Act, the pre-COVID-19 paid sick leave and safe time law, or 2020 supplemental paid sick leave. But employers can use this as an offset for paid leave they provided per a federal or local law in effect, or that became effective on or after January 1st of this year, if that leave was provided to an employee for any of the California's law's covered reasons.
And there's a question in the chat about whether or not employers will get a tax credit with this supplemental paid sick leave. No, but we are going to cover the American Rescue Plan Act, in just a moment, and that does provide for a tax credit.
So, how does this interact with other paid sick leave? Basically, it must be in addition to anything that was already provided. You may not require use of any other paid or unpaid leave, paid time off, or vacation time before the COVID-19 supplemental paid sick leave goes into effect. But you may require employees to first exhaust their COVID-19 supplemental paid sick leave prior to using Cal OSHA's paid sick leave. So I hope that makes sense to everyone. Determining hourly pay. So the 2021 supplemental paid sick leave pay rate calculations differs from the 2020 calculation, which required employers to pay this leave at the employee's regular rate for the last pay period, with the state minimum wage or the local minimum wage, whichever rate was higher. Under the new 2021 law, for non-exempt employees, generally there are two calculation formulas to complete before determining the rate of pay. The first pay rate calculation uses the employee's regular rate of pay, regardless of whether an employee works overtime in the work week they use leave. The second calculation requires the employer to divide the employee's total wages, excluding overtime premiums, by their total hours worked in the full pay period of the prior 90 days of employment. But if the applicable state or local minimum wage is greater than what either calculation produces, employers use that amount for the supplemental paid sick leave rate. So this is the highest of approach, which differs from the state's pre-COVID paid sick leave and safe time law, which, although it uses the same calculation formulas, uses an either or approach and does not require the rate to be at least the applicable state or local minimum wage.
I just wanted to take a moment to sort of answer two questions that came up in the chat really quickly. So the one question is, employee took 2 weeks in January and came back to work. He used FFCRA. This employee can't get paid for that time again under this California law, right? And the answer is they can actually. This is in addition to FFCRA leave. So if they took FFCRA leave, this provides an additional 2 weeks. And then the other question is, hypothetically, if a company decided to pay for the time employees took for vaccination prior to SB 95, would time credited to the employees count towards the offset? Yes, it would.
Okay, so for exempt employers, or for exempt employees rather, employers calculate supplemental paid sick leave in the same manner they calculate wages for other forms of paid leave. Although the 2021 law does not define exempt, an exempt definition is included in the state's pre-COVID-19 paid sick leave and safe time law. Moreover, under that law, the state labor department in an opinion letter said employees are only exempt if they are executive, administrative, or professional employees. So you're only dealing with the most common three, I think, exemptions that Angela and I see on a daily basis.
Yeah, and so for the easy way to say that is, whenever you have an exempt employee take time off, take a day off, you give them the pay. You basically take their weekly salary divided by 40, and that is their hourly rate times 8.
Okay, so whether exempt or otherwise, like the 2020 laws, employers need not pay more than $511 for each day an employee uses this leave. And the maximum total caps out at that $5,110 overall. A provision unique to the 2021 law, however, does allow employees who have maxed out because of the pay caps to use other available paid leave that they have top up. So they are fully compensated during that absence. Employers must provide accounting to employees, and this just went into effect this week. This was as of March 29th, 2021, so you're getting the most up-to-date information. You must set forth the amount of COVID-19 supplemental paid sick leave available on the employee's itemized wage statement or other writing provided on payday. So basically on the paycheck stub, have a spot on there that talks about this. If you're with one of the bigger companies, hopefully they did that correctly on if you pay employees this week, either on Friday or at the end of the month. Hopefully your payroll company helped you with that. Go ahead, Angela.
But you should always double check.
Absolutely.
There have been a number of times in the past year where some of the bigger companies have actually erred on this, and only because our clients were smart enough and observant enough to catch this, they were able to correct it. But definitely, after this webinar, give a call to your payroll provider and just say, hey, so you're aware of this new California law, right? We do need to go ahead and note this on the employee's next pay stub, and just make sure that you double check with them.
Right, absolutely. And then for variable schedules for employees who work, those types of schedules, employers must conduct initial calculation of COVID-19 supplemental paid sick leave that's available and indicate it as variable next to the calculation. And this must be updated when the employee requests leave or any records under the labor code, section 247.5. You need to update itemized wage statements and provide new information to employees on the next pay date on or after March 29th, 2020. So this affects a lot of us who had a pay period this week. And this applies retroactively going back to January 1st of 2021. So if an employee has taken a qualifying leave since January 1st of 2021, which was not paid for by the employer must pay for the leave upon the employee's request. And it must be paid on or before the payday for the next full pay period after the request is made, which I think Angela touched on earlier. And this must be reflected on the paycheck stub or itemized wage statement on the designated pay date. So the California Department of Industrial Relations has made a model poster publicly available, which employers must display in their workplaces. If employees do not frequent a workplace, because a lot of people are still working remotely, employers can distribute the poster electronically by email. We've been saying that for the last year. If you do have a remote staff or any employees who work remotely, you can send it by email. And then we also recommend putting it in a folder to where they can access it if they need it. That's available to your team. Like it did in 2020, California requires information concerning the supplemental paid sick leave be available on pay stubs or other written notices employees receive on payday. Also, like 2020 standards, there's a provision that says the pay stub requirement is not enforceable until the next full pay period following the date that the law takes effect, March 29th. So I guess if you did have a pay period this week, don't stress about it too much. It can be the next full pay period. The 2021 law incorporates into the statute guidance the Labor State Department issued concerning the 2020 pay stub requirement. Specifically, the 2021 law expressly requires that the supplemental paid sick leave and pre-COVID statutory paid sick leave be displayed separately. Additionally, for part-time variable hour employees, the 2021 law says employers may meet their pay stub obligations by performing an initial calculation of supplemental paid sick leave available and indicating that it's variable next to the calculation, which employers need to update when an employee requests the use of such leave. And a final supplemental paid sick leave related pay stub requirement concerns true up payments for leave employees used before the law took effect. Specifically, the retroactive payment must be on the pay stub for the pay period during which the payment is made. And I see a few questions in the chat. I think Angela's helping us respond to them as we go, which is so great to have you here. Okay, so some employee obligations. Employees alone determine how many supplemental paid sick leave hours they need to use. Similarly, um, with some exceptions, employees get to choose whether they will use supplemental paid sick leave or some other paid or unpaid leave benefit their employer provides or the law requires to cover an absence. Employees can use the 2021 leave immediately when the law takes effect if they make an oral or written request to use the leave. And the 2021 law does not contain language allowing employers to ask employees to provide verification or documentation to substantiate the need for leave. And assuming the state labor department does not change its 2020 position, employers might only be able to ask for reasonable supporting verification or documentation if they have evidence that an employee is abusing their entitlement to leave. So that's really the only time you can ask if you think an employee is abusing it. Okay, Angela, is there anything we should cover right now that you see?
So there was a question about the pay stub notice. The question is, does it need to include information regarding to SPSL pay that has been given or that is available for the employees to utilize? What should be on the pay stub is what is available. Same as if you're talking about vacation leave or sick leave. It needs to be what is available for the employee to take. And then for SB 95, if an employee had to take time off for taking care of a family member, is the pay rate partial like in the FFCRA, or is the calculation, as mentioned before, what is the highest calculated rate? So under SB 95, it wouldn't be partial. It would be for that 80 hours, it would be the highest calculated rate.
So to get into the American Rescue Plan Act, just as a quick refresher, I want to remind you of the provisions of FFCRA that we talked at length and at nauseum last year, hopefully. The FFCRA was that 12 weeks of leave due to school closure, unavailability, and up to 80 hours of emergency paid sick leave for certain COVID-19 related qualifying reasons, right? And although it officially expired December 31st of 2020, the FFCRA was extended on a voluntary basis for employers, and the ability to obtain the payroll tax credits were extended until just Wednesday, March 31st of 2021. Employers with 500 or fewer employees should decide now whether they wish to claim tax credits for employee leave taken in the next 2 quarters of 2021 for reasons related to COVID-19 and update your policies. As we've previously talked about, the FFCRA's requirement that employers with fewer than 500 employees can extend their paid sick leave benefits, which was supposed to expire. However, the tax credits continue to be available for covered employers who provided paid leave to employees for the FFCRA for qualifying reasons through the first quarter of 2021. The American Rescue Plan Act provides employers with the opportunity to obtain tax credit for offering an additional 10 days worth of paid sick leave to eligible employees during the second and third quarters of 2021. And that would be April 1st of 2021 through September 31st of 2021. Additionally, the American Rescue Plan Act expands the coverage of the type of sick leave that qualifies for a tax credit. So under one prong of the FFCRA's Emergency Paid Sick Leave Act, an employee was entitled to paid leave only if he or she was experiencing symptoms consistent with COVID and seeking a diagnosis. The American Rescue Plan Act modifies this eligibility category to eliminate the reference to COVID-19 symptoms, presumably in light of the fact that carriers of the virus may be, asymptomatic, but imposes the condition that such employee has been exposed to COVID-19 or the employee's employer has requested a test or diagnosis. The specific additional qualifying reasons we're going to get into in a few minutes. But in addition to the other 4 qualifying reasons for taking paid sick leave under the Emergency Paid Sick Leave Act, the American Rescue Plan Act makes the tax credit available if the employee is taking paid leave in connection with obtaining immunization related to COVID-19 or recovering from an injury, disability, illness, or condition related to the immunization. So that's the big difference. The tax credit, which I know someone was asking about earlier, the tax credit for leave in connection with an individual's own health condition, including vaccine-related leave, remains equal to the employee's regular rate of pay and maxes out at that $511 per day. And the tax credit for other forms of sick leave remains capped at 2/3 the regular rate of pay, up to $200 a day. The American Rescue Plan Act also provides tax credit for an additional 12 weeks of partially paid leave under FFCRA's Emergency Family and Medical Leave Expansion Act, which with a significant expansion of qualifying reasons. Angela, do you want to say something here?
Yeah, just there's a question, is ARPA separate from SPSL? And what's the difference? So that's what Cindy was just going through just now. There are two. The ARPA is the federal act. The SPSL is the California Act. ARPA, the leave provided under ARPA is voluntary. It is a voluntary. It allows employers to voluntarily extend FFCRA leave through September of 2021. The SPSL, which we have thanks to SB 95, is mandatory. In California, it's mandatory, and you must provide it. You get tax credits for ARPA, no tax credits under SPSL, but you can, starting April 1st, moving forward, if you provide the 80 hours of leave, they run concurrently, right, from April 1st on. And it provides a whole new bucket of 80 hours. If you provide leave, then you can take the tax credit under ARPA if you've voluntarily decided to extend that. So it just makes sense to extend because we do have a supplemental paid sick leave in California that's mandatory. You might as well extend it voluntarily because then you can get the tax credit, if that makes sense.
Great. And then just to touch on that last point about the 2-week waiting period. So ARPA eliminates the FFCRA's initial 2-week period of unpaid leave, but keeps the maximum tax credit equal to 2/3 the employee's regular rate of pay, regardless of the qualifying condition, which maxes out at the $200 per day. So accordingly, the maximum amount of tax credit available to an employer under the provisions of ARPA have increased from $10,000 to $12,000. So, and I wish there was an easier way to break this down. We're really doing our best. So I feel like it's very wordy, but okay. So basically, Angela, I'll let you kind of go through those questions that just came in, but the American Rescue Plan Act adds additional qualifying reasons to take paid sick leave under the FFCRA for purposes of qualifying for tax credits, right? And Angela just kind of touched on this. The additional reasons: the employees obtaining the vaccine, they are recovering from something related to the vaccine, or the employee is seeking or awaiting the results of a test after an exposure. ARPA adds non-discrimination and anti-retaliation provisions, which prevent an employer from cherry-picking which of the qualifying reasons under the FFCRA it wishes to recognize, or to which employees it wishes to extend them, and takes an all-or-nothing approach to the leave entitlement. Specifically, if an employer fails to comply with any requirement of the emergency paid sick leave, amounts paid by such employer with respect to such paid sick leave or family time shall not be taken into account as qualified sick or family leave wages. So No credit is available if an employer discriminates in favor of highly compensated employees, full-time employees, or employees on the basis of employment tenure, like those long-term employees with such employer. So ARPA adds $7.25 billion to the popular PPP program and expands eligibility to internet-only news publishers, some tax-exempt groups. I won't go through those with you in particular, just because they probably don't apply. The previous deadline to apply for the second round of PPP was March 31st of this year. However, a separate PPP Extension Act extends that deadline until May 31st of 2021. And that was just signed into law this week. So if you haven't gotten a second PPP loan, you still have time. And Angela and I know some great bankers if you want an introduction to anyone. But ARPA establishes other notable benefits aimed at assisting small businesses as well. So these include, for example, the Restaurant Revitalization Fund. I think it was $28.6 billion, provides grants to eligible entities for pandemic-related revenue loss. ARPA also sets aside substantial sums for other small business loans to support vaccination efforts, school reopenings, health insurance, and other similar endeavors responsive to the pandemic and its far-reaching consequences. ARPA extends unemployment benefits in a few key ways. It adds $300 per week for individuals collecting any form of unemployment compensation through September 6th of 2021. The $300 addition extends a benefit previously scheduled to expire on March 14th. The pandemic emergency unemployment compensation benefits originally extended under the CARES Act are extended until September 6th as well. And then the pandemic unemployment assistance benefits, which were also part of the CARES Act, and which may become available once an individual exhausts extended unemployment compensation benefits, are extended as well until September 6th of 2021. And I will say this, if we have smaller businesses, the pandemic unemployment assistance benefit also applies to individuals who are self-employed or who otherwise are seeking employment but are not eligible for traditional unemployment compensation benefits. That's been extended as well. In addition to all of these extensions on unemployment, ARPA permits an individual or each spouse to exclude $10,200 in unemployment benefits from federal income tax as long as the household income is under $150,000. So this means that if both spouses receive unemployment compensation and their total household income is under $150,000, they can exclude $20,400 from their federal income tax. What's not included? Basically, no increase to the federal minimum wage, no elimination of tip credit, and no paid leave entitlement. I also wanted to cover in this presentation, maybe too many topics, but we're talking about returning to work now that things are opening up and more people can get vaccinated. Before we start going into that topic, I just want to make sure that we cover layoff and furlough. A layoff can be temporary or permanent. A furlough involves reducing the days or weeks that an employee may work. However, the labor commissioner go ahead, Angela.
Really quickly, this has been teased out over the last year. What's the difference between a layoff and a furlough? Again, a layoff happens when there's no work happening, whether that's for a week, whether that's for a month, whether that's forever. It means no work is happening. A furlough is, say, going from having people come in 40 hours a week to having them come in, 20 hours a week, or having people, come in for 8-hour shifts, and now we've reduced it down to 5-hour shifts. It is a reduction in hours or number of days worked, whereas a layoff, no work is happening.
Just one more thing on this slide. The labor commissioner has said that for purposes of timing a final paycheck, a layoff and furlough are the same. So both a layoff and a furlough, assuming eligibility requirements are met, would entitle the employee to receive unemployment benefits. So some furlough issues that we see have definitely cropped up for clients over the last year. For your non-exempt employees, you can schedule them for fewer days and hours without liability concerns. You don't have to pay them for time not worked, right? They are, unless reporting time pay applies, of course, but they're hourly. For your exempt employees, it's much more complicated, right? Because as Angela said, you can't just take an exempt employee who is working 40 hours a week and automatically cut them down to 20 hours a week and reduce their pay by half if if they go under the minimum salary threshold. So additionally, it's more complicated because if any work is performed in a work week, you must pay that exempt employee for the full week. If no work is performed, then no salary is owed, but you want to have good records because if they do one email for you or take one phone call, you could get into some trouble. And then you have to provide advance notice to any reduction in schedule or pay. And you want to be mindful that reducing an exempt employee's salary may bring them below that minimum salary threshold for exempt status, and then they may need to be reclassified as non-exempt. I think that's a really big key takeaway where we see a lot of clients getting into some trouble. And then additionally, a furlough longer than 10 days or one whole pay period, whichever shorter, triggers an employer's obligations under the final pay regulations of Labor Code 2021, and therefore the employee is considered terminated. So you want to check your benefits policy to determine if you can still provide benefits to furloughed employees. Termination obligations apply regardless of whether it's involuntary, voluntary layoff, or furlough. And those obligations, and we can send anyone a list who wants them, but it's basically notice to employee as to the change in relationship, Form 2320, your unemployment benefits information, the final paycheck on the last day of work, including accrued vacation time and business expenses to date. Paid sick leave is not considered wages, so it's not paid out upon termination. But you also want to provide that COBRA notice and health insurance premium notice. And just because we're terminating, you want to ensure you document the reason for that termination. There's been a lot of confusion during the pandemic regarding the difference in meanings of, layoff, furlough, termination. So don't rely on that term to explain the reason for the termination. And if it is performance-based, document it. If it's due to lack of work, document it, just so it's really clear. Okay, the key question we've been getting over since the vaccines come out is, to mandate or recommend. And we've done a few webinars on this, so if you've already heard this, you can skip or fast forward or tune out. But supply is still somewhat limited, and the vaccine is only being offered to certain specific populations. It's very difficult to mandate the vaccine in the workplace as of right now. However, very soon the vaccine will become more readily available to everyone, and the question will become more pressing for employers, right? Do I mandate or do I simply recommend the vaccine? And even then, your decision will need to be an informed one, and it will need to factor in logistical issues, public health policy, community consideration, as well as legal and employee relation considerations impacting each worker or groups of workers. So yeah, you want to take those things really into consideration in what you decide ultimately is best for your company. But on March 4th of 2021, the California Department of Fair Employment and Housing updated its FAQs. And so we got a little bit more insight onto exactly what they're thinking. And the Department of Fair Employment and Housing is responsible for enforcing the California Fair Employment and Housing Act, go figure, which prohibits California employers from discriminating against employees based on certain protected characteristics, including a disability. So FEHA mandates that employers engage in the interactive process with employees to provide reasonable accommodations to employees with statutory disabilities so that they can perform the essential functions of their job. And many of the FAQs that just came out are consistent with the EEOC's responses. So just a couple key provisions that Angela and I wanted to cover today. basically confirms that employers can mandate that employees receive an FDA-approved vaccination without violating FEHA, so long as the employer reasonably accommodates employees' disabilities and sincerely held religious beliefs or practices. Similarly, it confirms that employers must engage in the interactive process with employees who have a disability related reason or sincerely held religious belief not to be vaccinated. And the FAQs emphasize that an employer must determine the availability of a reasonable accommodation on a case-by-case basis. If you need any help with that, Angela and I are here for you to go through that with you. It's a process. In addition to working from home as a reasonable accommodation for disability reasons, they suggest that employers and employees consider reasonable safeguards and procedures that employers might be able to put in place so that employees could work at their work sites without endangering themselves or other employees or third parties. The FAQs state that FEHA does not require employers to reasonably accommodate employees who simply refuse to be vaccinated that don't relate to a disability or sincerely held religious belief. So basically the anti-vaxxers, if they claim that they're an anti-vaxxer and they get no vaccines whatsoever, that would not count unless, of course, it is due to a disability or religious belief. Those are the two exceptions. The FAQs also provide that employers may discipline employees who refuse to be vaccinated so long as the discipline is not retaliatory. For example, employers may not discipline an employee for requesting a reasonable accommodation related to his or her known disability or religious belief or practice. Likewise, the FAQs reiterate that employers may not retaliate against an employee who claims that the employer's vaccination policy intentionally discriminates on the basis of race, national origin, or another protected characteristic, or has a disparate impact on a protected group. The FAQs also provide that employers may discipline employees who refuse to be vaccinated as long as it's not, I think we just covered that, as long as it's not, retaliatory. And the EEOC has provided some similar guidance in December of 2020. So this is what the EEOC's position is, and that is the Equal Employment Opportunity Commission. They've been updating their guidance pretty regularly, and they've allowed a little bit more flexibility for employers in terms of medical inquiries to permit inquiries regarding COVID-19 symptoms and medical examinations for COVID-19 testing, right? The EEOC took the view that the pandemic met the direct threat standard, which we've talked about ad nauseum last year. And so vaccinations are not a medical examination. The vaccination does not have to be a job-related thing or consistent with a business necessity, and employers can mandate vaccines or request proof of a vaccine. In fact, I know one company who is providing $100 to every employee who shows a fully vaccinated card that you get when you get your vaccine. Angela, is there anything you want to add at this point for the EEOC? No? Okay, perfect. All right, so for voluntary vaccinations, employers need to remember that there are two components of the voluntary nature of the vaccine, right? Choosing whether or not to be vaccinated or responding to pre-screening questionnaires. The choice is voluntary. You basically don't want your employees to be harassed by other employees for failure to participate. So if you are considering mandatory vaccinations, they're permissible, but you want to take a lot of care based on excluding an employee from the workplace who indicates that they cannot receive a vaccine due to a disability. And that's when we get into the ADA. That allows an employer to have a qualification standard that includes that an individual does not pose a direct threat to the health or safety of individuals in the workplace. And the EEOC, per the EEOC, this requires an individualized assessment as to whether a direct threat exists. And this is basically the elements of a direct threat. The duration of the risk, the employer must look at the nature and severity of the potential harm, the likelihood that the potential harm will occur, and the imminence. How close is it to happening? So for example, If employees were working on site during the entire pandemic, the direct threat standard is probably pretty hard to meet unless there are specific extenuating circumstances. Obligation to accommodate. If the employer determines that the individual who cannot be vaccinated due to a disability poses a direct threat at the work site, the employer cannot exclude the employee or take any other action unless there's no way to provide a reasonable accommodation absent undue hardship that would eliminate or reduce the risk so that an unvaccinated employee does not pose a threat. Because you as the employers do have the right and the to keep really all of your other employees safe. So at this point, if there's no reasonable accommodation that exists that would eliminate or reduce the risk, the employer needs to determine if there are any other leaves, rights, policies that apply, which would assist the employee. So for example, a remote work policy, FFCRA leave, FMLA or CFRA leave, or other employer paid, unpaid leave options. If the employee cannot be vaccinated because of a disability and there is no reasonable accommodation possible, then it would be lawful to exclude them from the workforce or from the workplace, excuse me, not the workforce. It doesn't mean you should automatically terminate the employee, but the employer should be consulting with your legal counsel, whether it's Angela and I or anyone else that you're working with, to determine if any other rights apply under these laws. Because there's just so much here, federal, state, local, prior to terminating. So consult your legal counsel, whether it's us or anyone else. And then similarly, if an employee indicates that they are unable to receive a vaccine because of a sincerely held religious belief, a lot of care must be taken before just removing them from the workforce. And this request needs to be taken just as seriously as a disability request. This is pretty broad and it has to be sincere, but there's, it's a low burden essentially to establish undue hardship when dealing with religious accommodation. So you want to use the same approach.
There were a couple of questions on this.
Yeah.
I mean, I think what you can ask them to provide is a written statement and have them sign it. At this point, we don't have much guidance as to what a sincerely held religious belief actually means. But you should enter into that dialogue with the employee and say, okay, what is your objection? I need you to provide a written statement saying that you're not doing this for religious reasons. And then there's a way to accommodate it, like Cindy was just saying. The same thing goes with medical exemptions from vaccine. The same sort of process would apply, right? They say, I can't get this vaccine because of my health condition. You would determine, okay, well, what is it? Are there accommodations that we can put in place to either make sure that that person is not interacting with other people? Can we have that person work from home? Figure out if there's a way to make it work, as you would with any other condition.
Yeah, exactly. And the EOC has basically said that you want to assume that an employee's request for a religious accommodation is based upon a sincerely held religious belief. If, though, you have any sort of objective reason for questioning either the religious nature, the employee's sincerity of that particular belief, practice, observance, then the employer, like Angela said, would be justified in requesting additional supporting information. But that's it's very, very loose. It's a very low standard.
It's a really tricky discussion to get into.
Yeah. And the question, would the employee have to state which religion? What's funny about that is, as far as I know, and Angela, correct me if I'm wrong, no religion or commonly held religion or commonly held beliefs actually say that you should not get the vaccine.
There are churches that I've seen, churches that are anti-vax, but no major umbrella religion does. It's possible that there is a church that an employee goes to that is anti-vax. I've seen people claim that at least. Um, yeah, I mean, would the employee have to state which religion? I mean, I think that that is a valid question to ask and have them put in their written statement. I don't think that that necessarily violates any sort of privacy laws, because they are stating this is the reason that I'm not getting the vaccine. So I think that that's a reasonable question. Um, a lot of these inquiries that you're posing to us right now are sort of up in the air, and we'll know more as cases start to roll in. um, you know, and we'll update you at the next webinar.
All right. So we've talked a little bit to clients about incentive programs. You can do those cash awards to engage in certain behaviors. Most vaccine incentive programs are not subject to EOC regulations like some larger ones. I'm just going to leave it at that because we have a lot more slides to get through and some privacy issues. Even though the EOC does not consider a vaccine a medical examination, you still need to be careful of HIPAA and the California Confidentiality of Medical Information Act, which basically requires employers to protect the privacy and security of any medical information they receive.
So if you are requesting a copy of their of proof of vaccination, you need to hold that. If the employee gives you a copy of their vaccination card, that needs to be put in the same place that you would hold any other medical records.
Yeah. So a question, is should you mandate that employees receive the vaccine? It really goes into your company culture, right? Like employee morale, employee relation issues. Those are worth mentioning as a consideration to decide what's best for your business with a vaccination protocol, right? And there's been surveys done that Angela and I have read of employees stating that employees are surveys shown that employees are much less likely to want to get vaccinated if it is mandated. So just some things you want to think about from an employee perspective, COVID fatigue, financial insecurity, everything that's gone on in the last few years. And these are things that the employees bring to work with them every day. And so you want to consider these factors. Also, different categories of workers are eligible for different timing of things, their location, their age, all of these things you want to take into consideration. And engage with your employees, right? As you're considering whether to implement or recommend a mandatory vaccine program in the future, just consider that vaccines are still at the EUA status, the emergency use. No, that's not right. I'm forgetting offhand what's the EUA status. And they are authorized but experimental. Focus on the facts, be very fact associated, and consider some obstacles in advance. We're having clients bring in trucks so people can get vaccinated. Just some key takeaways, engage and support the public health efforts. They focus on fact-based messaging. One or two quick new cases that have come out. Rounding is permitted under certain circumstances. That's when calculating the number of hours worked, the labor commissioner typically will accept this practice of computing working time by rounding, but proceed with extreme caution. And as a practical matter, we don't recommend rounding at all. So if that is something you're doing, please reach out to Angela and I. This Donahue case just came out in February of 2021. I've never recommended it to clients. I think it's not a great thing to do. But basically, the Supreme Court held in Donahue that a meal period of less than 30 minutes or taken after 5 hours of work creates a presumption that that meal period is non-compliant. And the court held that employers must either provide an hour of premium pay, which is that meal period penalty, for such non-compliant meal periods or provide evidence that they chose to voluntarily waive. And so if you do have a rounding policy, please, please, please talk to Angela and I or whoever your employment lawyers are to make sure that you're in line with the law, because it doesn't look good for those types of companies who do that. And I won't even get into the Garcia case, but an employer's delayed enforcement of arbitration provision does waive the right. So if you have your employees sign arbitration agreements, please keep them at the tip of your hands so that we can use them later on when we need to. Senate Bill 1383 greatly expands CFRA to include businesses of 5 or more employees and new eligibility reasons for taking that leave. We touched on it briefly earlier, but this expands to what a family member means, and there's no age limit to child. So grandparents, grandchildren, siblings, spouses, the usual as well. Some additional changes are these things. You can read more about it or ask Angela and I, but it's now 11:01 and I have an 11 o'clock call with a client, so I have to get off. But no matter who your employment attorney is, Angela and I are here for you, but we want to make sure they are checking in with you a couple of times a year. Stuff is changing so fast, especially right now and especially in the last year. And we're always here for you. We have an experienced team of attorneys. I know a lot of you know Angela one-on-one and of course myself, but we have some other great attorneys in the office as well. And something we do every time a client is facing a lawsuit or has a red flag of an employee is a liability assessment. What do the documents look like? What is at stake, so that they can make an informed decision on what's best for their business. Do we take this to trial? Because Angela and I love going to trial. We have no problem with that. Or do we need to settle because there's a lot of money at stake? So we'd love to keep in touch. Here's all of our information: email, phone, and office. And we hope we were able to answer all of your questions throughout. I don't see any open right now. We've answered at least 28 questions, and some questions came in through the chat as well. So I really appreciate everyone being here this morning, and thank you all. I hope you all have a wonderful Easter, and if there's anything that we can do, we're always here for you.
Give us a call.
Yeah, thanks. Bye.
Bye, everyone.